Good morning. Good morning, everyone, and good morning to those of you in our virtual space. We know there's probably just as many of you out there who are watching us on our YouTube channel, so we appreciate you being with us today as well. Thank you for coming today. My name is Jill Rockwell. I'm the Batten School's Dean of Students, and we are here today for Batten Hour, which, as many of you know, is a time when community members come together with students, faculty, staff to talk about some of the most pressing policy issues that our nation and world are facing. Today is a really special Batten Hour. We're celebrating it in recognition of Constitution Day, which actually was last Friday, but Monday is a much better time for student events. So we're celebrating Happy Birthday Constitution a couple days late. And it's also extra special because it's being organized and run by one of Batten's journals, the only journal, the Virginia Policy Review. And so they came to us early in the summer and said that they were interested in hosting the Constitution Day Batten Hour, and we really appreciate their initiative and their leadership. So now I'm going to turn the podium over to Marissa Lemma, who is the VPR's editor-in-chief, for our introductions. Thank you.
Hi, everyone. Thank you all so much for coming. As Dean Rockwell said, my name is Marissa Lemma, and I'm the editor-in-chief of VPR. We are super excited to be hosting today's event, which is called Previewing the Supreme Court's High-Profile Term, Guns, Abortion, Religion, and Race. We are super excited to be joined by Bob Barnes, who is a Washington Post Supreme Court reporter. He's been a Washington Post reporter and editor since 1987. He joined the paper to cover Maryland politics, and he has served in various editing positions, including Metropolitan Editor and National Political Editor. He has covered the Supreme Court since November of 2006. Today's event will be moderated by Ethan Betterton, who is VPR's managing editor. So without further ado, I will pass things over to Ethan.
Am I good now? Can you hear me? Okay. Yeah, thank you so much for being here today, Mr. Barnes. I'm just going to launch right into it. As Marissa said, our title for today is Previewing the Supreme Court's High-Profile Term, Guns, Abortion, Religion, and Race. It certainly sounds like a very loaded and high-profile term. Just how high-profile is it?
Well, first let me just say thank you for inviting me. I appreciate it very much. I'm glad that you're here. I love it when people are interested in the Supreme Court. And I look forward to your questions as well as Ethan's. I feel like I'm supposed to say something really lofty by being here. So, stakes were kind of raised when it was moved over here to the rotunda. But I appreciate you having me, and I look forward to talking with you. Every term, it depends on the justices, and that sounds like kind of a crazy thing to say, but the justices take on these cases, and they decide how big they're going to be, or how small they're going to be, how broad their ruling is going to be, or how narrow it is going to be. But certainly it seems that the court has taken on a very ambitious agenda. Now, one thing to realize about the court, if you don't know, the court takes the cases that it wants to take. It receives a huge number of what's called cert petitions. It decides what it's going to do. It's maybe 1% of the cases they take. And so the court doesn't just sort of think, okay, it's time to do something on abortion, although there's a little bit of that, or it's time for us to take on this issue. The cases rise up, and the court decides whether or not it's sort of the time to do it or not. But they don't just usually don't just go out and pick things. That said, this court has taken a guns case after refusing for a decade to take a Second Amendment case, and they've taken one that is very close to cases in the past they have decided that they wouldn't take. The same is true with abortion. This is the Mississippi law that we'll talk about is one that the court has heard this issue or been presented with this issue before and decided not to take up. And so I think it's, really inescapable to say that the court's changed membership is the reason that some of these issues that the court in the past has put aside, it's willing to take up now. As I say, how broadly they want to rule on those or how incrementally they want to move, that's something that we won't know probably until next June or so when all of these decisions come down.
Thank you for that. So going off of your comments about the importance of the justices, a really interesting comment Justice Breyer made about 2 weeks ago now, I think. He mentioned that he thinks Congress ought to consider term limits for justices. And he also stated his intent that it's not his intent to die on the court. First, how do you see the conversation on term limits playing out going forward? Is there anything to be said about that, or is that just a nice idea? And secondly, given Justice Breyer's statements, do you think he's going to retire at the end of this term?
Well, let me take that first one first. It's interesting, there is this commission that President Biden has set up to look at issues of Supreme Court change, reform. Journalists are told not to use the word reform because that indicates it's an improvement and we're not taking sides here, but everyone else says reform, so I will too in this context. But anyway, they're not to make a recommendation, apparently, but just to sort of air these issues and talk about the problems that might come with them. One of those, I think, is term limits that, I see in looking at the testimony and looking at public polls and just hearing people talk to me. I think there is like a great support for term limits. It strikes people that it is wrong for sort of any public official to have lifetime tenure. And the problem, of course, is that's what the Constitution says. It says that federal judges, Supreme Court justices, will serve in good behavior, meaning the way to get rid of them is to impeach them, but that's really the only way if they have done something that is impeachable. And so while I think that there is this a lot of support for term limits, it is the very hardest thing to accomplish. I think most scholars would say that it would require a constitutional amendment. There are some proposals that would say, no, you wouldn't have to do that. The person would be moved off the Supreme Court, or they would take some sort of senior status. They'd still be a judge, so they'd still be serving in good behavior. But that's a very, unsettled matter of law. But I do think that it has a lot of appeal. It does come with problems. If, say, it's an 18-year term, what happens at the end of that 18-year term? Is there a rush to get some cases decided before that justice rotates out? Is there, would that justice be looking for a new job somewhere else? And would his or her judgment be questioned because of that? And also, as we've seen how hard it is in confirmations, what if it was the president's term to nominate a new justice, but the Senate of the other side was in the hands of the other side and said, we're not going to confirm? Then you don't have a court of full strength. So there are a lot of issues to be taken into account, but it's certainly one that I see a lot. My favorite testimony from someone before the commission, a law professor at Chicago, said, only the Ayatollah, the Pope, certain members of the Mormon Church have lifetime tenure. And that someone said, well, also college professors. But at any rate, we're the only country that has such a system. And so it's one. Now, I don't make predictions about Justice Breyer. He'll do what he wants to do when he wants to. I didn't think he was going to leave this past term, even though I have never seen such pressure on a Supreme Court justice to leave. I mean, usually you might get a discreet op-ed or, whispers about it's time to go. I mean, in this case, you've had a truck circling the Supreme Court saying, retire Justice Breyer. I think that I don't know how productive that is in getting a justice to decide it's time to go. He is 83. He's in good shape. I don't think you would know his age if you listened into oral argument. He wrote some of the court's biggest decisions last term. He likes his job. They all like their job. He says, believe me, I've tried to get him to answer that question. Many others have too. He says there are a lot of things to take into consideration, including his health, but he's not ready to make the decision yet.
Gotcha. Thank you. So I am conscious of the fact we do have several cases to get through. So I will jump into the first one, the guns case, which is New York State Rifle and Pistol Association versus Bruin, who is the superintendent of the New York State Police and is therefore in charge of issuing or not issuing concealed carry permits. Can you explain just a little bit about the case for those of us that aren't too
Yeah, I'll
familiar?
try to give it to you in pretty general terms. Basically, New York has a system that to get a permit to carry a gun outside the home, you have to show a sort of special reason that you need one. For self-defense, that is. You can get one to go hunting or that kind of thing, but to carry a gun, a concealed weapon, because you are worried about self-defense, you have to have a special reason, and state officials or some public official gets to decide whether or not you have met that standard. It's different in practically every state. Every state has a slightly different way. Some, don't have this kind of requirement at all. Some don't, I think, even require a permit. But it has been sort of left up to the states. The court, as you all know, in Heller, decided that there is a constitutional right to own a gun and to keep a gun in your home for self-defense purposes. But this raises the question of what kind of constitutional rights do you have outside the home? As I said earlier, the court has in the past passed on all of these. Practically every state, Maryland has one, Massachusetts has one. Every state that has a very restrictive permit, it has been challenged in the past. And upheld as something that government can do. And the court has declined to take any of those cases. They have accepted this one. I think that shows a real change on the court. Justice Thomas has been complaining that the court won't take one of these Second Amendment cases. He says the court has turned the Second Amendment into a second-class right. And so he has been pushing for it, but so far, court wouldn't do it. It now has a majority that I think is much more favorable to gun rights. They took one case last year, another case from New York. New York basically saw what was coming, threw in the towel, changed the law. The legislature said you can't pass a law like this. It was a very restricted law on transporting a weapon. And the court had to declare the case moot and didn't reach a decision in it. And so it then declined a bunch of other cases, but then took this one. So I think that shows the court is ready to make a move in this area of Second Amendment rights.
Gotcha. One of the most interesting things about that case that happened, I think, in the last week was an amicus brief that was filed by several pretty fairly conservative lawyers, notably Jay Michaelotti, who was a UVA law grad, actually, that basically argued the Second Amendment, the Constitution, absolutely has the right to that weapon possession can be regulated outside of the home. What do you make of that, given their ideological bent?
Well, I think that there are a number of conservative judges who think that yes, there is a right, but just like with every other right, the First Amendment rights or any other right, government does have some room for restriction as long as it's not denying that basic right. You know, we hear a lot about originalism and trying to decide what the framers were doing, what the founders thought at the time that the Constitution is written, when laws are written, when constitutional amendments are passed. And Heller, the decision that said that there was a right to own a gun in the home for self-defense, you know, both sides in that went back to, it was basically an originalist opinion on both sides. They went back and looked at the time and looked at what laws were in place, and 5 decided one thing and 4 decided another thing. And so, you know, while originalism is often seen as, you know, a way to sort of take politics out of it or take personal preferences out of it and look back to the past, we all know that it's sometimes hard to figure out exactly what happened in the past or what those in the past meant. And so it's not completely surprising that there are conservative judges who feel that way. And I think that they would probably say this might not be their policy judgment. They might think it's a stupid policy and that New York should allow more people to carry weapons for self-defense, but that it's not unconstitutional for New York to have this law.
Right, gotcha. So we'll move on to the next one now. Dobbs versus Jackson Women's Health Organization. This is the Mississippi abortion law case, and I suppose if you'd like to, you could talk about the Texas abortion law too, because that one's certainly interesting. Can you just give us a little bit about both of those, and maybe interestingly, why one and not the other is being heard?
You know, it's a little complicated. Let's talk about the Mississippi case first. That's the one that they took. They held on to that case. I told you these cases come up. And the justices, one, decide when they're going to take them and whether or not to take them. That Mississippi law was there for a very long time at the court. What it does is it says that Mississippi won't allow abortions with very limited exceptions after 15 weeks. The lower courts that looked at it said that that's in clear conflict with Roe v. Wade, which says that states can impose some restrictions on abortion, but they can't basically ban abortion before the point of viability, which is usually considered to be 22 to 24 weeks. So Mississippi's law was clearly outside that window. It was clearly a challenge, seen as a challenge to Roe. The lower court said, well, no matter what we think of Roe, this is what the Supreme Court says. This is the law of the land. Supreme Court reaffirmed in a case called Planned Parenthood v. Casey 20 years later. And so it's not up to us to declare that this law can be constitutional when the Supreme Court says that it can't. So that case came to the court while Justice Ginsburg was still alive. Nothing happened to it. Justice Ginsburg died. She was replaced by Justice Amy Coney Barrett, who has been very critical of Roe v. Wade and has said she's personally opposed to abortion. And it still went on forever and ever that the court didn't do anything. Those of us who cover the court, that often means to us that the court's not going to take the case, but someone's writing a dissent from that decision saying, we should have taken it and we should take other cases like this. That's what we were all expecting. Instead, one day on the orders list, it says that they're going to take the case. So it's another case where I don't think that means that the court is necessarily ready to overturn Roe v. Wade, but I think it does mean that the court, the changed membership of the court has had an impact on whether it's willing to look at these issues and see if there's something else they should be doing, whether it's time to sort of update that guidance that they gave in Planned Parenthood v. Casey. And so that case, I'm sorry, am I doing something wrong? That case has not been scheduled yet for oral argument. It'll probably be in December, but we don't know for sure. The briefs are being filed now. In the meantime, this Texas case comes along. Texas case is it's a completely different law. It would ban abortion after 6 weeks, but state officials are not in charge of enforcing that ban. They have given it to private citizens to bring civil actions against anyone, not the woman who would have the abortion, but anyone who would aid or abet the woman having the abortion. And the sponsors of it are quite clear that the reason they went that route is they wanted to avoid just what happened to the Mississippi law and to all the others, where federal judges say, it's not up to us, this is clearly unconstitutional after Roe. State officials, you can't enforce it. In this case, there are no state officials to enforce it. And so it was clearly drawn as a way to sort of get around that and to go into effect, unlike all of these other laws. So the court split 5-4 on whether or not to let that law go into effect. They said that it could. The 5 said that it could. The 5 expressed questions about its constitutionality, but said it was not that was no reason to not let the law go into effect. Most laws do go into effect. The 4, well, 3 of the 4, Chief Justice Roberts said he wouldn't have let it go into effect. He thought it was too unusual. He thinks other states will do it. He thinks the courts really have to look closely at this question of outsourcing enforcement of a law. The 3 liberals were furious by the decision, saying that it was a clearly unconstitutional law and that there was no way that their colleagues should have let a clearly unconstitutional law go into effect. And so that's where you have it. It's gone back. It might come back to the Supreme Court again. In fact, I feel quite sure that it will. Right now, it's back to the Texas state courts. And just yesterday, a doctor in Texas, he's either retired or he is about to retire. He wrote an op-ed in our paper, the Washington Post, saying, I performed an abortion against Texas's law because I think it's unconstitutional, and I think that women have the right to abortion before viability. Clearly, he publicized it. He thinks he's going to be sued. He seems to say, bring it on, that it's the only way to really test the law in the courts. And so, as far as I know, unless I missed something this morning, no one has sued him yet, but that's clearly the intent, is to try to get that case moving through the state courts in another way. As you also know, probably the Justice Department has sued to try to stop the law, saying it's unconstitutional. So there'll be a lot of legal maneuvering on the ground in Texas for a while before it comes back to the Supreme Court.
I hope it's working now. Thank you for that answer. Very fascinating. I predicted that there would be a doctor who would publicize it like that, but it would definitely be interesting to see how that case specifically plays out. Moving on to the religion case, Carson v. Macon, can you go into a little bit detail about that and maybe touch some on the difference between religious status and religious use, because that seems to be the main issue at play here.
Yeah, well, I think that there's a real, if the court, there are trends at the court, and certainly one trend at the court that I don't think anyone would deny is that religious organizations are having a much better time at the Supreme Court now than they did for a very long time. They have won just about everything that they have brought to the court about COVID restrictions, about schools, about the ability of religious organizations to fire and hire employees without violating some anti-discrimination laws. So religious groups are on a roll at the court. This one is a little bit of a follow-up. Maine, apparently, I don't know if any of you are from Maine, and I didn't know this, some places in Maine are too small to have their own public schools. They have vouchers for parents so that they can send them to other schools instead of providing education for their children. The law said that you can spend this money or send your kids to a private school, but not to a private school that involves religious instruction, and that violates the Constitution's separation between church and state, that there are things government can do for religious organizations, but not, the court has said, specifically send money that would go for religious instruction. So that's being challenged now. The religious groups say that this is just the next step in what the court has already improved in the past for religious organizations, and that the lower court was wrong to try to draw this line now. And so, as I say, the religious groups are having a very good run at the Supreme Court right now, and I would be surprised if that didn't continue, although this does certainly bring up an issue that the court in the past has said public funds can't be used for religious instruction. And so that's a line that has been there for a while.
Is there another goalpost, I suppose, for lack of a better term, after this one, or would this be kind of the final
I'm sure there
straw?
will be, but I don't know what it is yet. I mean, the obvious one is going to be what happens when someone's religious beliefs conflict with anti-discrimination laws. The court has picked at that twice and not really settled the underlying question. They've found ways out of it both times. Once with the baker who wouldn't make a wedding cake for a same-sex couple, they found that the decision by the Colorado Human Rights Commission was tainted by animus about his religion. They didn't really settle the question. They took another case last term involving Catholic services, providing foster care services, but they wouldn't vet same-sex couples. The court found a way out of that one without settling the issue. And then it declined to take a case about a florist in Seattle, not Seattle, but in the state of Washington, who refused to provide flowers for a same-sex wedding. And she had lost in the Washington State Supreme Court, and the Supreme Court decided not to hear her case, which was a little bit of a surprise, except that I think the court just isn't ready to confront these cases head on right now. So the religious groups were upset that the court didn't take that case, but that's the big one that's sort of waiting out there, I think, and the court clearly isn't quite ready to take that on.
Carson versus V. Macon is the appetizer, I guess, to a certain extent. The last case that I have here is not actually one that's on the Supreme Court's docket yet. Students for Fair Admissions versus the President and Fellows of Harvard College. They've said that they're not going to pick it up, is my understanding, until the Solicitor General weighs in. So can you give us a little bit of background about that case?
Yeah, this is another of these long-running cases at the Supreme Court about affirmative action in college admissions. And this one involves Harvard. The twist here is that some of the plaintiffs are Asian Americans who say that they were discriminated against by Harvard's policy. Harvard looks at race along with a host of other factors in deciding who's going to get in. And, you know, for years, Harvard's policy was sort of held up as the standard for others to meet because it was one factor among many. It didn't seem to be too far one way, too far the other way, but now it's under challenge. It has won so far based on Supreme Court precedents. There's a similar case that's going on at the University of North Carolina, and so there's a private college case, there's a public college case that are advancing. It was a little bit of a surprise that the court asked for the Solicitor General's opinion because almost everyone knows that the Trump Solicitor General, the Trump Justice Department, was on the side of the students and against Harvard. Everyone thinks that will switch. The Biden administration will be on the side of Harvard, so we're waiting to see what the SG says, and then the court will decide whether or not to take the case. I don't know about that. I thought for a while it was like a no-brainer that the court was going to take this case. I wonder now if the court would be more interested in having a public school case than a private university case, but we'll see.
Thank you for all that. I am conscious of the time, and I'm sure
and I should tell you, we always sometimes think that the court's docket has been set when the term begins, and that's not the case. The court continues to add cases, so it could add this case or lots of others and still hear it this term. Basically, through January, the court can take a case and still hear it this term, and if it's a very special kind of case that came up, they can do a sort of an emergency thing. But in general, by the end of January, the court has taken all the cases it's going to hear that term. It hears oral arguments through April, and then it generally tries to get all of its opinions out by the end of June.
Gotcha. Thank you. So we'll turn it over to audience questions now, because I'm sure that many of y'all have great questions to ask. Who wants to go first?
Someone has to go first.
Yeah, Casey.
First, thank you so much for coming and speaking with us.
Thanks.
It's really reminding. Under kind of the religion umbrella you were speaking, you said that the court wasn't ready to take on a case, and I was wondering if you could kind of expand on why they're not ready, or maybe like what they're waiting for to take on.
Oh, I wish I knew. You know, the court is transparent in some things, in that the court, the court loves to say it's extremely transparent, that all the briefs that are written are available to the public on their website. Their oral argument is in front of the public. They explain themselves. They each have to sign on to an opinion and say why they voted a certain way in a case. It's very rare that a justice just says they're on one side or the other without signing on to something that explains the reasoning. This is not one of those areas. The court often doesn't say why it won't take a case. It simply, without comment, will turn it down. And so those of us who cover the court are often left to, I like to call it educated speculation, that we know sort of what they've done in the past. We sort of think of why a case might not be the right one at the right time, but we don't really know because the court doesn't explain that. The court also doesn't explain, when it takes a case, how many of the justices thought that was the right thing to do. It only takes 4 justices to grant a case. Obviously, it takes 5 to come to a decision. And so, for instance, with this abortion case that hung around for month after month after month, we don't know what made the court decide finally to pull the trigger and say we're going to take it. We don't know which 4 justices, or if there were more, who wanted to take it. And so this is one of those things that we're just sort of in the dark about a little bit. And so we can kind of speculate, but we don't really know. You know, I think it is generally true that when the court makes a big decision about something, they may not have decided all of the issues in it, and there may be another issue that's obvious issue out there. The court may not want to take up that issue in the next year. It might want to send down its opinion, let lower courts apply that to these cases, and I think they like to call it percolation, you know, see what happens and what cases come up after that. And so in those cases, I think it makes sense that they don't want to take another one right away that's similar to the one they just had or would answer a question. But otherwise, you know, I'm sorry. I wish I could give you a good answer because I wish I knew it.
Yeah, Aubrey.
Thank you for speaking with us.
Thanks for being here.
Thank you. You mentioned that religious groups are having a much better time at court recently. Is this true of like all religious groups or just Christian groups? Are they being just as favorable to non-Christian religious groups bringing cases?
Well, it's interesting that you bring that up. There is, you know, the court has just taken a case on a really quick turnaround involving a death row inmate in Texas. And this death row inmate wanted not only to have his pastor, Christian pastor, in the room when he's executed. He wanted the pastor to be able to pray out loud and to lay hands on him, which he says is important in his religion. Texas would not allow that. They said it's disruptive of the execution process and wouldn't do it. Comes to the court on an emergency basis. The guy's going to be executed that night, just hours before his execution. The court stops his execution, not only issues a stay, but says, we're going to take this case and we're going to hear it, and they're going to hear it November 3rd. And this is a kind of turnaround that's hugely, you know, almost never happens at the court. Now, it's a Christian case. There was a death row inmate who was a Buddhist. He wanted his spiritual advisor with him. The state, and it was either Alabama or Texas, I'm sorry, I can't remember which one, Alabama, said, no, we only allow prison chaplains in, and we have a Jew or a Christian. Those are your choices. Or a Muslim and a Christian, I can't remember what it was now. But anyway, the court let that execution go forward and got really scalded from across the sort of religious spectrum, both liberals and conservatives, Christians and Muslims. And then there was a case involving a Muslim prisoner. They stopped that execution. And it sort of moved along in that now there is a little coalition of liberal and conservative justices who say that a condemned person should have a spiritual advisor of their choice with them at the time of execution. And so they'll hear this case to see just what other limits can be put on that. So on the one hand, yes, it's the Christian cases that have gotten the court to move, but there was also a Muslim case in which that happened. And in this case, there was pretty much support across the board for this. So.
Yeah, right there.
Thanks so much for being here. Just a quick question. So, I mean, obviously administrations nominating judges that lean their way is not new, but in your opinion, do you think we're reaching a time now where the politicization of the court is, you know, to an alarming level, or is this, excuse me, this just business as usual? And then the follow-up is, if you see this getting more polarized, where do you see the court going in the future?
Yeah. I do think it's more polarized. I think that, as you say, it's always been this way. I once heard Justice Scalia talk, and someone said, you know, if I want to be a federal judge, what do I do? And he said, well, get involved in politics. Because it's the senators who make the decisions about who the federal judges are going to be. And so there has always been this sort of strange case in which you have to be somewhat politically active to get the attention to become a federal judge. And then the minute you become a federal judge, you're supposed to be, everyone's supposed to forget that past. You know, as the Chief Justice Love said, there are no Obama judges, there are no Trump judges, there are no Bush judges. We're all just judges trying to do our best. And President Trump said, please, you know, of course there are. And so that's always going to be out there, no matter what they do. And we can all see patterns in which Republican-nominated judges vote one way on a certain issue, Democratic on another. It doesn't always happen. But I think there is a new recognition of how important federal judges are on the Supreme Court and you know, on the federal courts, and the stakes are higher. The Republican-controlled Senate got rid of the filibuster while President Trump was in, and it really opened the door for approving judges on party line vote. And you have seen the exact same thing continue now that Democrats control the Senate and they are Democratic nominated judges. You know, one interesting thing, we all wrote an awful lot, because it was true, about what a good job President Trump did in getting his nominees on the bench, and that the Republican Senate pushing them along. President Biden has actually gotten more circuit judges on than Trump did at this point in their presidencies. So it's clear that both sides are playing this game now, and they see the importance of it. You see some strategic retirements so that they can fill those slots while Democrats still control the Senate. You know, I think it's too bad that party line votes have become the thing. I don't think it's good for the system if a Supreme Court justice can only be approved if the party of the president and the party that controls the Senate are the same. That seems like a problem, but it does seem that's the direction we're moving in.
Any other? Yeah,
There's a guy right there in the red cap.
Hey, so thank you for joining us today. My question actually follows off of Gary's question. I saw that you actually tweeted this out, but the Quinnipiac poll results show that since 2004, this is the lowest job approval rating among voters for the Supreme Court. Do you think the Supreme Court is experiencing a legitimation crisis because of this politicization? And more broadly, what do you think the court will respond to worsening public opinion of its performance?
Well, I think two things about that. One, I think it's very difficult to really poll about the court and get super meaningful results. You know, I'm sorry, it kind of reflects badly on me, I guess, but you know, there was a poll the other day done. You know, we have all written about Justice Breyer over and over, and whether he's going to leave the court. And turns out in this poll, I think it was 26% of people knew who Breyer was. 42% of people said they had never heard of Stephen Breyer, never even heard his name. So they couldn't even tell you if he's doing a good job because they'd never heard of him. So, you know, you take that into account. And I think that the reason that the court in the past, the public in the past has sort of thinks the court's doing a pretty good job is you get a conservative opinion that some people agree with, and then the court gets a liberal opinion or one that would appeal to liberals. And, you know, they keep that one in mind, and it's kind of the last thing they heard about the court. In a way, I think that affects their opinions. But all that said, I do think the politicalization and the feeling that the court is political is going to hurt the court. And that's not just me. I mean, the justices are very worried about that. You see them talking about it all the time. The Chief Justice very much worries about the court's legitimacy. And when he does speak in public, which isn't that often, it is almost always to try to advance that goal. And do I think that it sometimes affects the court's opinion? I think it does. I think that the court sometimes looks for a narrow opinion or a compromise or something that would be sort of more palatable to the public than a stark decision on one side or the other.
Anyone else have any questions? Yeah, Professor Platt.
Okay.
Do you find, we were talking about this earlier, that it's hard to, there's some things that are hard to figure out about the court. And as a reporter, my impression is that people covering an executive or legislative, they have all these insiders who are giving them. Is it harder to get inside information on the court because it's such a small, tight body?
Much harder. There aren't really scoops on the Supreme Court beat. We all sort of get information pretty much about the same time. It's hard to penetrate. Some people are better at it than others, but you know, I joke that people say, you know, is it hard to get a justice to go on the record? And I said, well, not if they're selling a book. Because if they've got a book coming out, it's pretty easy to get an interview and they're happy to talk to you. Otherwise, not so much. The clerks do not talk. They take a vow to not talk about what happened that year that they're clerking for a justice, and they're pretty good at sticking to it with good reason. And so it's very different from any other kind of journalism beat, I think. Now, to me, what's interesting about it is, not only am I learning about these 9 people and trying to write about them and what direction they're moving in or what the trend is, every year it's like fascinating issues that come before them that are usually hard, and usually lower courts have disagreed on them, and there's some really good stories about the people that, you know, every case has an actual human, or most of them do, at its heart. And so to me, that's really fascinating. It's almost, I say, like being back in college where, you know, you learn about all sorts of interesting issues. You learn enough to like take the test, which in my case is write a story, and then you forget about it. But it's really fascinating for that reason, to my mind. But it is a different kind of reporting than most other reporters do.
Yeah, Val, you got the last question.
Just as a follow-up to that, you learn a lot of cool things. Do you have like a pet favorite Supreme Court case, decision, or opinion?
Well, you know, I get this question, and I should come up with better answers. But I'll tell you, maybe one way to answer it, the most emotional thing I saw at the court, I can tell you that, and that was the day the same-sex marriage decision came down, Obergefell. I've never seen a scene like that at the Supreme Court. Usually, it's, you know, all decorum. There are secure. I mean, it's like it's actually illegal to, you know, demonstrate on the plaza of the court, our bastions of First Amendment. But still, you can do it on the sidewalk, but not on the plaza. And so after that decision, after I had written for a while, I came out to go back to my office. It was just packed with people. I've never seen anything like it. So it was a very emotional and interesting thing to see. And then this will sound a little crazy, but you know, I covered This case involving the Westboro Baptist Church, who you might know, the people who picket at every event and say, pretty bad stuff about people. And I went to visit them at their church in Kansas. Turns out it's basically just one big family, but at any rate, they let me go with them to protest this thing, and we had I went to their worship service and felt like it was being directed at me a little bit, but it was still like fascinating to me, and I kept trying to think to myself and to remember that I was really privileged to get to see this for myself, not read about it or see something, but to actually see it and try to understand where they were coming from and the issues in this case. And so even while all this stuff was going on and they had done a banner that I think was kind of directed at me, I still thought, how lucky I am to be able to see this for myself and try to figure this out for myself and try to explain it to readers. And so that's how I think about my job, and that's how I think about these cases. They're just really interesting a lot of the time, not all the time.
Well, that, I believe, is just about an hour, so I think we'll wrap it up here. Mr. Barnes, thank you so much for joining us
If anyone
today.
wants to ask me something afterwards, go free.
Thank you from Batten and
Great, thank you.